Okay, so good morning. Today's daf is Bava Kamma daf Kuf Hey 105. Um, we are near the bottom of Kuf Dalet and Bet. Let me share my screen and we'll really get started. So yesterday we noted two aspects of our Mishnah that imply that the 1/5 penalty required of people who swear falsely about a monetary debt is itself a monetary payment and not simply about forgiveness. Meaning that it's not about what the asham is for, the korban asham, which is also brought by somebody who swears falsely. That's about, atonement, but this is about really a debt. And as a result, and what were those two items? The first is that the liability of the 1/5 penalty does not trigger an obligation to travel to Madai to pay for it, right? So if it's just money, so the guy will come back. You don't need to race around the world. It doesn't need to be an example of 80, around the world in 80 days, where I can't remember, but I believe at least in the cartoon version, I think there's somebody who's sort of following them the entire trip. The point is that you don't need to chase around the world somebody whom you just owe money. But if it's part of the forgiveness process, if you can't bring your asham until you actually return it, then it makes total sense why you would need to go around the world, because you can't bring your asham. You can't get to, full atonement until you've actually returned the item. So that's one aspect. So the fact that you don't have to chase around the world shows that it's money, not an aspect of forgiveness. And the second is that the 1/5 payment could itself be the subject of a 1/5 penalty. Meaning, if the robber swears falsely about the 1/5 payment, saying that he already paid it when he didn't, and then he admits it, well, then he's going to owe a 1/5 penalty on that, all the way down until the item itself is until the penalty would be less than a pruta. Okay, so as a monetary debt, if the robber dies, so then the heirs are going to be liable for that 1/5 payment. Now, in an extended brisa that we quoted yesterday, we learned a separate rule, and it said that whether or not the father and son swore falsely, doesn't matter. Could be that they both swore falsely, could be neither of them swore falsely, but no matter what, the son is obligated to pay back the principal, and he's not obligated to pay the 1/5 payment. So we're trying to figure out, how is that consistent with the concept that this is a monetary debt, that the 1/5 penalty is a monetary debt, and would thereby be something that a son would be obligated to pay on behalf of the father. So what's the case that brisa is talking about, where the principal is liable, but the 1/5 penalty is not? And we can't say that it's based on whether or not somebody swore falsely, because the brisa itself says that we're talking about all the situations. Son swore falsely, father swore falsely, both of them swore falsely, neither of them swore falsely. Bottom line is, every one of those situations is supposed to be covered by this brisa, because the brisa explicitly says that it covers all of those situations. So we concluded yesterday, Rav Nachman had explained that in the brisa we're talking about where the father did not confess, right? So he never said that he was liable for the item itself, and also obviously therefore never said that he would be liable for the 1/5 penalty, notwithstanding the fact that he may or may not have sworn. So, but the son did confess. He admits that the item that is right now in front of us at the moment, we're going to say, is the item that was stolen. And he admits it never belonged to my family. It clearly was yours. It was stolen. I agree. And so that's why he's going to be liable for the principal, but not for the 1/5. And we ended by wondering, well, 1 second, if the son's confessing, well, then assuming that he actually swore and lied about it before he confessed, obviously, he swore and lied about it, why is he not liable for the 1/5 penalty? After all, we're saying that he's liable for the item, and the item is a monetary debt, And so as a result, why, when he lies about it in an oath, is it not treated like a monetary debt and make him liable for the 1/5 penalty? So that's the question that we asked, and we're going to now pick up with the answer. The answer we pick up with the start of the fourth line from the bottom. It's the second to last narrow line on Kufdal and Amabet. Amri, b'she'ein gzelas kayemes. We're talking about a situation where the item that was stolen no longer exists. Okay, so and that's why when the item that was stolen no longer exists. So let's take a look at Rashi. Rashi says, "B'she'ein gzela kayemes." It's 1, 2, 3, 4, 5, 6, 7, 8, 9, 12 lines up, 11 lines up in the Rashi on the narrow lines. That there's no basis on it to pay. Titanan hagozel umachil as banav peturim milashalim. That if you steal something and you feed it to your children, you're not obligated to pay. Hilkach ikafar, if you actually deny it, well then kfiras dvarim ba'alma. You're only denying words, and so as a result, he ufshvuas bitoy hu deleka chomish, and this will just be a denial oath that is not obligated in a 1/5 penalty, and so as a result, that's why we're talking about that, and that's why we're talking about something that doesn't exist. 1 second.
Where's this Rashi?
This is Rashi, correct?
Where?
This was the Rashi. It began 11 lines from the bottom of the narrow lines in Kufdal and Amabet.
What's the first word?
B'she'ein gzela kayemet is the Divrei HaMaskil, and then we said began Delav Aleh Ram Yad Lishlam. So the point is that we've seen that there's no basis for saying that there is liability for the 1/5 payment, because there's really no liability in the first place. Well, 1 second, but but if the item itself doesn't exist, why does the son have to pay the principal either? We just said that it's not actually that if you steal something, you feed it to your children, and then after Admei Esrim, you pass away, and now your children are adults and they inherit your estate. They do not have any obligation to pay back. So lo tzricha deika achrayas nechas. So it must be where there's real property. Oh, okay. So now let's see what's the story with the why does real property in the estate make a difference? So Rashi tells us again. We're 1, 2, 3, 6, 7 lines up. Lo tzricha deika achrayas nechasim. But amrin lekamen, we're going to see shortly. And it's you can see that it's the same citation as we had above. Kufyud Aleph Hamabet. So basically, in a week, that if in fact the father leaves the children, the father who stole the item and fed it to his children, leaves real property that creates a lien, that is something that a lien can be held against, well then chayavin lahachzer. Then there is an obligation on the children to return it, in order to show respect to their father, in order to essentially enable their father to get some level of atonement. So as a result, then there is an obligation. So again, what have we learned? We've learned that if somebody steals something and feeds it to their children or otherwise consumes it so it no longer exists, and now passes away, and the children have the obligation to pay back. And again, the man never confessed, and so as a result, there's no liability that triggered as a result of a live confession. So it's only a liability that falls on the children. Well, then the children don't have an obligation to pay back unless they inherit real property. If they inherit real property, well, then we'll say that they have an obligation to pay back. So, okay. Yes, you have a question?
Well, what are they paying back?
They're paying back the amount of money that their father stole.
The value of it, but if they stole, if he stole an object, they can't pay back the object, right?
Well, remember that we're now talking about, we're dealing with a situation where the object no longer exists.
Right, exactly.
So he can't, obviously they can't pay the object. So they're paying back the value of the object at the time of the theft. That's the amount that is due. And so that's exactly so that's the story. So right now we're dealing with a situation where the father did not confess. The son does confess. He admits that the item didn't belong to his father, and he wants to, and he inherits land. So therefore, he's paying back the principal. And because it's not a formal obligation, he's only doing it for the respect of his father. There's no obligation to pay back the fifth. But we're gonna clarify that right now. Who cares whether there's real property? So milva al pehi, any kind of robbery is just an oral loan. Meaning, if you need to pay back a debt of having stolen something, it's like there's a loan against you, and except that it's an oral loan. It does not trigger any liability on the estate. Umilva al peh eino gova lo mina yorshim v'lo mina lekachos, and you don't take an oral loan from the heirs or from the purchasers. So Amre, so we're going to further clarify the situation, okay? And we're going to say amad bedin. It's where the father stood for judgment and was found liable. So he never confesses to the liability of having sworn falsely, but he was found to have stolen the item and therefore was liable. Well, 1 second, Ibisha Badin, Afilu Chomish Nami Mishalim. Well, 1 second, if he stood for judgment, well, then the fact that he stood for judgment turns the loan that we said was like an oral loan into a written loan. And a written loan, you can't have a liability on property. And so now it's a real debt. And so why shouldn't that be considered a monetary debt, and say that the son, if he swears falsely, he should be liable for a 1/5 penalty.
So conviction is like confession then.
Conviction, not quite, because
Not quite, but for the purpose of din, it's like a confession.
for the purposes of the principle, it's like confession. Exactly. So Amar Rav Huna, B'rei de Rav Yoshua, Lefisha Ein Mishalman Chomish Al Kfiras Shibud Karkos. Because if the only method of your liability is the fact that you're holding land against which there is a lien, and you simply deny the existence of that lien, that is not an item for which you are liable a 1/5 penalty. And Rashi helps us out here. Take a look, third line in the narrow lines of Rashi. Lefisha ein mishalman chomesh al kfiras shibud karkos. To chomesh, amai ka'asi. What does chomesh go on? Ashru asa. Okay, on an oath. But lav shvuahi, but this is not considered an oath, even if he actually swore. It's not the kind of oath that a chomish applies to, because the kaimel under shvuas, because we is set up in the laws of shvuas, ein nishban al harkarkos. We don't swear on land. Vahai ben, and this son, ki ishtaba, when he swore kafar la shibud hakarkos, he was denying the lien against the land. That's an oath about land. Because after all, if there was no land, if there was no real property, he wouldn't have an obligation to pay back. And so as a result, there would be no shibud against him. There would be no shibud against the estate, and the children would not have to pay back. So we've learned a lot of different concepts here. So let's take a quick look and summarize. The final answer is that when the father has become fully liable for the principal and the 1/5, so i.e., he admits that he swore falsely and is seeking atonement, well, then even his heirs will need to pay it. Pay the 1/5, pay the principal. But if the father is found liable in court regarding the principal and never admits to swearing falsely, then his heirs will be responsible for the principal and not the 1/5, even if the heirs swear falsely about it, because that oath that they're swearing falsely about is actually about property, real property, and not about the underlying loan. That's answer number one. And now we're going to see that there's another answer that we can give for why a son might not be liable for the 1/5 payment, even though one, he admits that his father stole the item, and two, he's swearing falsely. Rava offers that alternative. Rava Amar Hachabamayaskin. Here's what we're talking about. The saddlebags of the father were deposited with somebody else. And guess what was in that saddlebag? You guessed it, the stolen item. So Karen Mishalim Dahaise, he has to pay the Karen because it's right there. Now again, remember, I should have noted in this final answer that the final answer is also talking about where the actual item no longer exists. Because if the actual item still existed and it was still in front of us and the son swore falsely, well, then that would be a monetary liability that he would have sworn falsely about and would be subject to the 1/5 penalty. So I should note that as well in that comment that we're talking about where it doesn't exist. But here now Rava says, yeah, no, it can exist. It's just that the son didn't know about it because it was by another person. Daha Ise. So it is existent. And Chomish lo Mashallah, but he doesn't pay the 5th. Because when the son swore that he didn't have it and he didn't owe anything, he was swearing honestly. He had no idea about the contents of his father's saddlebag that happened to be left with a friend. Daha lo havayada. He didn't know. So that's the story. And so that gives us another explanation for, again, how the son could be liable for the principal and not liable for the 1/5, even if he swore falsely and his father swore falsely. And even if he's now admitting that he swore falsely, because we're saying, and we're dealing with a situation where he didn't swear falsely intentionally, and so as a result, he's not going to be subject to the 5th. Okay.
What was
All
the
right.
again? How was the connection with the land? Is there shibud on the karka? Why was that relevant?
Why was that important?
How
Okay,
did
excellent.
land get involved in this?
Excellent question. So the shibud of the karka was key in this example because when the item doesn't exist, that is the only situation where there's liability on behalf of the yorshim, on behalf of the heirs. So that's why that was important. And it was that basis, the fact that it was only a lien against the property that leads to the children having to pay the judgment and pay the principal. That's why an oath about it does not trigger a 1/5 penalty, because an oath about property is not the kind of oath that is subject to the 1/5 penalty. And this is really an oath about property, because the denial in that situation is that there's no lien against the property. I mean, he can use the words, I don't owe you anything, but the fundamental subject of that oath is a denial of the lien. And a denial of a lien on property is not subject to the 1/5 penalty. So those are the two important aspects of why we need to say that there's a lien on property. One is that it triggers the children's liability, and the second is that it exempts an oath because it's oaths on land do not trigger the 1/5 penalty. So that's why we had to talk about real property in answer number one.
So that's automatic. If they inherit property, there's it's an automatic lien of the stuff on the property. But if the children don't inherit
remember,
property, if he has no property,
it's an automatic lien because the court found that the father stole. If the court had not found that the father stole, no, the son could even admit that but then it's there would be no lien, and there would be no formal obligation on the children at all to pay back. So it's important that there was the father stood for judgment. That's an important element of this. Okay.
But if there was no property to inherit, there would be no lien against property.
That's exactly right. And then there would be no liability. And therefore, that's why that can't be the case that we're talking about. Remember, the answer that we began by thinking about this morning is to say, oh, we're dealing with a situation where the robbed item no longer exists. But that wasn't enough, because in that situation, you don't even owe the principal. And that's why we had to say, oh, okay, it doesn't exist and there's real property. So now there's a lien. And now but then we said, well, 1 second, even real property isn't enough if all we have is just that the father stole and he was never found guilty. You need the father to have been found guilty for the debt to be considered one that is subject to a lien on property. And then we can say, okay, and now we can explain why the children are subject to the principal, because there's a lien on their property. And we can explain why the children are not subject to the 1/5 penalty, because even if they swear falsely, it's just an oath about a land and not oath about a debt. Okay. So that was a good opportunity to do a little bit of chazara on this situation. So now the next wording of our Mishnah is chutz mipachas mishav pruta bekeren. That when the principal is that's left is worth less than a pruta, then you don't have to go chasing around the world. So we're going to talk about situations where there's less than a pruta that's left. So Amar Rav Papa lo shanu ela she'ein gzela kayamis. Well, when we say that, we're talking about a situation where the robbed item doesn't exist. About gzela kayemes, if it still exists, you need to tzerek leilech agrav. You got to chase the person, because chayshinan shema tiakir. We're worried that even though the item that you're trying to return right now may not be worth more than a pruta, but what happens if its value goes up? Then there will be a big problem. On the other hand, there are some who say that Rav Papa's statement was the exact opposite. Amar Rav Papa loshna gzela kayemes v'loshna she'ein gzela kayemes. When we say that you don't have to chase the person if it's not worth a pruta, it doesn't make a difference whether the item exists. Because we're not worried about it going up in value. So we have these two different views. And it seems like we follow the second version, as is often the case. And so we would focus on the fact of what is it worth at this moment. Now we're going to have, Rava is going to note some related, again, rules. So Amar Rava Gazel Shalosh Agudos B'Shalosh Prutos V'Huzlo V'Amdu Al Shtayim. If you steal 3 bundles that are worth 3 prutos, so each bundle is worth a pruta, and then they decrease their value and it goes down to 2 prutos. Im Hechser Lo Shtayim. What happens if you now return 2 of them? So now what's left in your possession is worth 2/3 of a pruta. Well, that's less than a pruta, so maybe you don't need to return it. Well, you do need to return it, because you need to return the other one. And Rashi tells us it's about it's right opposite. In the Gemara, you'll see that there's some language in brackets, Kavan Demi Kara Havishava Pruta. Right opposite on the right-hand side, you can see Chayav Lahachzer Lo is the Divrei Maskil of the Rashi. And so let's take a look. Chayav Lahachzer Lo, Aguda Acheres. You need to return that last one. Because even though that last one is not worth a shava pruta, when you stole it, it was worth a shava pruta. By la dure, that you have to return it, and to chase after him. Because at the end of the day, as a reminder, the value of what you have to pay back is determined by the value at the time it was stolen. And so here, you'd have to pay it back. So now we're going to ask a question. Vitana tuna. And we've got a support for this approach that Rava says. In fact, because of the Mishnah that we saw back on Tzadik Vav Amabet. Guzzle chametz va'avar alav Pesach. If you stole chametz and Pesach passed, so as a result, the chametz is now prohibited to benefit from. So Omer lo hareisho chalafanecha. The thief is allowed to say, "Here's what's yours in front of you." So you can take it back as it is, and you're stuck with this worthless chametz. Taima de'ise be'ene. The reason that you can give it back like that is because it still exists. If it didn't exist, even though now it's worthless. Since it was worth something at the moment that you stole it, then you have to pay it back. You'd have to pay the original value. So Hachanami Avagata Hashta Lo Shava Pruta, even though it wasn't worth it's now not worth the Shava Pruta, this third bundle, Kavan Demi Kara Hava Shava Pruta, since it was originally worth a Shava Pruta, boy Shalume, you gotta pay it back. So boy Rava. So now Rava asks about another case. Guzzle Shtei Agudos Bepruta. Let's say you stole two bundles that together were worth one pruta. Okay, so you stole something that obviously requires a return because the total value is a shava pruta. The hexerlo achas mehan, but you only returned one of the bundles. And so mahu, what's the law? Miamrin and hashta lega gzela. Do we say that? Listen, now there's no robbed item. What's left is worth less than a shava pruta, so it's as if it doesn't exist. O dilma holo hadar gzela dahava gabe. Or do we say no? Listen, the guy never returned the item. So how can you deal with it? So Hadar Pashta. So afterwards, Rava explained the answer. He answered it himself. Gzela ein kan, hashava ein kan. There's no robbery here, and there's no return here. Well, 1 second. If there's no robbery here, if there's no robbed item left, of course there's no return. Gzela ein kan, hashava yesh kan. If there's no robbed item, how could there be a return? So Haki Kamar. No, this is what Rava is saying. Even though at the moment there's essentially no robbed item left, i.e., there's no further obligation on the robber to return anything because what's left in his possession is worth less than a shava pruta. Mitzvahs hashava ein kan. He has not fulfilled the mitzvah of returning the item to his victim, and so as a result, if he wants to try and fulfill that mitzvah, he's got to return the remaining item. Okay, now that we had this interesting discussion, we're now going to have, and with this kind of twist at the end, where the question is, you've tried to fulfill something, and you've only done half of your obligation, or you haven't quite finished the obligation. We're going to talk about two other situations, one regarding a Nazir and a second regarding Tuma, where, again, similar kind of language you'll see at the end, where Rava offers responses. Amru Nazir Shekilach Vishir Shtei Sa'aros. We've learned, as we went through Maseches Nazir, that at the end of the Nazirut, one shaves all of their hair off their head. What happens if you left two hairs? Well, then lo asa v'lo klum. You've not done anything. So by Rava wonders. Listen, all right, you got two hairs left, and you shave one of them, and the other one falls out. Mahu. What's the law? So Amrle Rav Achabar Difti. Ravina, Rav Acha from Difti asks Ravina, I don't understand. Nazir shegilach achas kami by Rava. Was Rava actually asking a question about the process of shaving each hair individually? Because as Rava is asking the question, right? Rava says, what happens? You shave the second to last hair, and now the last hair falls out. But from a practical perspective, that's what happens if you shave each hair individually, and then you shave that last hair, and then second to last hair, and then the last hair falls out. And essentially, you've shaved every hair but one. And so, of course, it's a valid shaving. I don't understand why Rava would even ask that. So Amrle Ravina explains that, you know what? Here's what, again, this is what Rav Acha was explaining. So Rav Ina explains to Rav Acha, you misunderstood Rava's question. Lo tzricha kegon shenashar achas mehen begilach achas. The situation is where the one that fell out before the guy shaved the last hair. And so as a result, miyamrina and hashda miyas lekashir, do we say that, listen, now there's no unshaved hairs, so as a result, it's as if he had a valid shaving. Odilma halav giluachu. This wasn't a shaving. The meikara hashir shtei because his original shaving wasn't valid because there were 2 hairs left, and his final shaving, v'hashda kigilach lo havish soros, and his final shaving wasn't a valid shaving because there was only 1 hair left. So as a result, he never did a formal shaving, and so Hadar Pashta. So now we get Rava's answer, and you'll again listen to the wording, and you'll see why the Gemara brought it here. Seyar ein kan, giluach ein kan. There's no hair and there's no shaving that's here. So in second, ein seyar ein kan, iseyar ein kan, giluach yesh kan. Could there, if you were to say that there's no hair, could there ever be a shaving? Of course, there can't be a shaving if there's no hair. So what in the world is Rava trying to say? Hachi kamar, aval pisha seyar ein kan. Even though there's no hair left, mitzvahs giluach ein kan, the person has not fulfilled the mitzvah of shaving. So one more of these. So Amar Rava, Hare Amru Chavis Shenikva Ustamua Shemarim. If you haven't, now let's remember 2 things before I dive into and give you the translation. 2 things to remember. One is that skylights in those days were effectively doors to the upstairs, and you would put into the door, into that skylight, a ladder, and that would be how you get to the upstairs of a house. Now, if you have some tuma in the first floor of the house, and that skylight is completely open, because remember, they didn't have glass to cover the skylight. So, and that skylight is completely open. Well, then guess what? The tuma goes up to the upstairs. However, if you put a piece of pottery, earthenware into that and cover it up completely, so then the tuma will not go to the upstairs, because remember, there is no staircase separate from this. This is the staircase. You've closed it off. There's no way for the tuma to go to the upstairs. So that's with that background. And we're going to the starting place of this Mishnah, which is from Kalim, is that there already is a barrel that you placed into the skylight in order to stuff it all up. So the skylight is completely covered. And so now, but unfortunately, the barrel developed a hole. Ustamua shemarim. And the dregs that were in the barrel, they came and they closed up the hole. They sealed the hole. So then hitziluha, then that is sufficient, even though there's a hole, it's been stuffed up by the sediment, and so as a result, the tuma will not go into the upper level. So by Rava asked the following: Agav chetziyamahu. What happens if the hole that developed was half sealed? And now we're assuming that the hole is the minimum size for tuma to pass. Do we say that because the hole that's now existing, because the is less, or do we say no? When the stuff that's stuffing up the hole, because it's not stuffing up the entire hole, we should view the whole hole as there. So that's the question. So agav umahu. So agav chetziyamahu. So Amrle Rav Yemer la Rav Ashi. So Rav Yemer says to Rav Ashi, Lav Mishnah Seinu Heizo. Isn't this already said by our Mishnah? Ditnan chavish nikva ustamua shmarim hitzilua. If you have a hole and the sediment goes into it, it's no longer a problem. Pakaka bizumora. However, if you stuff it with a vine, ad shiim areyach, until you put where obviously there's going to be airspace around the vine, until you smear more mud, that will dry and become like a clay, until you smear more mud around that hole, then hayu or hayu by shtayim, or if you put in two vines, until you smear the clay all around to the remainder of the hole, and between the two vines. So then that's on if you do that, well then again the hole will be sealed and the tumor won't go upstairs. So taima de meirach, the reason that we consider the hole closed is because he sealed up the remaining opening. Hello meirach lo, isn't the implication therefore that if a hole is not fully sealed, the tumor would continue to pass through, and it's considered a whole hole? Mm-hmm. So amai v'tehevi ki agav chatzia. Shouldn't we say that this is a situation where half the hole was sealed? So doesn't this show that half the hole is not considered a good sealing? So Amre, they explain, no, hachi hashta. There's no comparison. Hasam ilo meirach lo kai. If in fact there was no smearing, so then the vine would not stay in. But here, when the hole is sealed with the sediment, and the sediment is partially sealed with the sediment, and the sediment is going to stay there, maybe that would be considered a closure. Well, unfortunately, the Gemara does not resolve Rava's question. But I don't know. Thankfully, we aren't at the moment subject to worries about Tuma and Tara in this kind of situation. But in any event, probably best not to be in a house that doesn't have staircases and only has a skylight to get upstairs and downstairs. Okay. In any event, that now allows us to return with other statements and questions from Rava. So again, Rava makes a statement and then has a question. And so now we're going to, and these are going to relate back to our topic of swearing falsely. So let's take a look. But Rava Hare Amru, that we said in our Mishnah, again, this Mishnah was the one on Tzadik Bava Mabet 96b, Gazal Chametz Avar Aleva Pesach, Omer Lo Hare Shal Chalafanecha. If you stole chametz and Pesach passed, so as a result, it's no longer worth anything because you can't benefit from it. So then you're allowed to say, look, what's in front of you is yours. Take it, and as a result, you'll have paid back the theft. So by Rava wonders, Nishba alav mahu. What happens if the person swore in this case about the chametz? Do we say that, listen, if the chametz was stolen, he'd have to pay? So mamona kfarle. So as a result, it's as if he's denying a monetary obligation. Odilma hashtamias hamanach. But right now, or you could say that, listen, the chametz does exist and it's right in front of us. And it's worthless. It's less than earth, frankly. Low kafar le mamona. And so as a result, you're not denying any kind of monetary obligation. So milsa de ibay le Rava pshita le Rava. That what was unclear for Rava was clearer for Rabba. Da'amar Rabba shori ganavta. That if you and we're going to see that Rabba thinks that money that stuff that stands for money or could stay, even though it may not be worth anything at the moment, is considered like money. Because if you say you stole my ox, who omer lo ganavti, I didn't steal it. Mativu atzlacha. So, and then the person says, well, 1 second, well, what is it doing by you? It's got my seal on it. You know it's mine. So, shomer chinam al yalav. Oh, I was just an unpaid watcher, and so chayim. If you actually swear that and it's false, you are liable for an asham. Sha'arei pater atzmo b'geneva v'aveda. Because why are you liable? Because if, in fact, by saying that you were actually an unpaid watcher rather than a thief who steals something and something happens to the item that was stolen, lightning comes down and strikes the cow and the cow drops dead. So then the thief is still liable for the original value of the cow. But if it was if he's an unpaid watcher, well, now all of a sudden, if it's stolen or lost, and certainly if lightning comes down from heaven, so then he's not going to be liable. So he's exempted himself from a liability. So therefore, that's why he is subject to having to bring an asham offering if he swears falsely in this situation, even though the cow is right in front of us and he can give the cow back. So Shomer Sakar on the alav, or let's say if the guy says, yeah, it's your cow, but I was a paid watcher. So now he's going to be liable for if it was stolen or if it was lost, but he's still chayav for an asham sharei pater atzmo mishvura umesa, because now he's still not liable if it were to break or die essentially on its own. And again, shoel ani alav, if he admits to being a borrower, well, he's still chayiv. He's still going to be liable for an asham. Shaharei pater atzmo memesa machmas mulacha. If he had worked the animal and in a proper manner as a borrower, he would still be liable for it. Alma afal gafta ha kaim. So even though the animal is still standing here, kaven to e mignav mamona kakafar. So even since if it was stolen, he's going to, and he denies he's really denying a monetary obligation because there is some theoretical liability that could exist. So hashtanami mamonika cover. But so now we're going to consider him to be denying a monetary obligation. So hakanami avagad de offer ba'almahu, even though this chametz is worthless like earth, kaven de imigniv boy shalumile mamona ma'alia. If somebody were to, for some whatever crazy reason, steal this chametz that got left over Pesach because they didn't know that it was chametz that was left over Pesach, and so they stole it. The original thief will need to give back the amount of money that the chametz was worth at the time of the theft. So hashtanami mamonika kafarlat. So as a result, he's actually denying money, and therefore he would have to be liable for an asham offering. So Yosef Rabba Kamma Hashmaita. So Rabba was teaching this, and Esvei Rav Amram Rabba, and Rav Amram asked Rabba, I don't understand this, and we're following the Hagos Habach here to indicate who are the participants in this argument. We've got a following brisa that the person denied it. So Prat Lamod Be'ikar. This excludes one who admits to the basic obligation. So in terms of somebody who swears falsely in denial of a monetary obligation. So when you have to actually deny the obligation. So Kate said, what is the case of denying of not denying the obligation? Shori ganapta. So again, you stole my ox. Lo ganapti, I didn't steal it. So again, the guy who's the victim says, Mativu etzlecha. What are you talking about? It's right there. I see it right there. So ata machartali, you sold it to me. Ata nasatali, matamatana, you gave it to me as a gift. These are all alternative things that the thief could potentially claim. Avicha macharali, your father sold it to me. Avicha nasanali b'matana, your father gave it to me as a gift. Achar parati rats. It ran after my cow, and that's how it's in my possession. Me'ilav ba'atzli, it came on its own into my field. Toa b'derech matzasiv, I found it wandering the road, so I brought it into my field. Shomer chinam ani alav, I'm an unpaid watcher. Shomer sakar ani alav, I'm a paid watcher. Shoel ani alav, I borrowed it from you. I didn't steal it. V'nishba b'hoda, and then he swears, and then he admits, you know what, I did steal it. So then, I might have thought in all of these cases that maybe he would be liable for an asham offering. Talmud Lomar v'chicheshba. We say that you have to fully deny it. So prat lamoda beikar. With this person has admitted that it's the original guy's. So as a result, he's not going to be subject to an asham offering. Now, I will note that if in fact a person says that you sold it to me and he did not, we are going to see that is a true thief. We are going to qualify a number of these explanations. But at the moment, the key question here that is being asked of Rabbah is, Rabbah, you said that if the person says he's an unpaid watcher or a paid watcher or a borrower, that you're going to be subject to an asham liability because you've reduced the liability associated with having to pay back if something were to happen in the meantime. But this brisa is explicit that you are not subject to an asham offering. So how can you make your statement, Rabbah? So Amar Le to Dura, as it's translated here, scatterbrain. Titanya Hahi. When was that brisa taught? Dika Amar Le Helach. That's where that brisa, where all of those cases that we were just talking about, where you say you sold it to me, you gave it to me, etc. I'm a paid watcher and I'm unpaid watcher, etc. All of those cases, it's a situation where the defendant immediately gives the animal back to the victim, and he says, "Here, it's yours." But Kika Amina, when Rabbah says, when did I give my situation where their asham would be where a person would be asham for a liable for an asham? The kaima ba'agam. That's where the animal is all the way out in the field. And you know what? And who knows what's going to happen between this moment when I admit to owing it to you, and when I actually bring it to you. So as a result, in that situation, if I swear that it was actually that I'm really an unpaid watcher, because if in the between the time that I go from right now to go and get it and bring it to you, it would be stolen, I would be not liable any longer if my words were honest. Therefore, Rabbah says, in that situation, you are subject to an asham. It's only in the brisa that was quoted by Rav Amram that only in the situation where you actually hand the animal back to the victim, that's where you don't have the liability. So now the Gemara is going to pause here and ask, what about that? Doesn't make any sense. How can you interpret the brisa that way? Because atamachartali, the brisa says that you sold it to me. So my moda beikar ika. What kind of admission is there? It can't be a case of you're giving it back. Isn't it a case of you're saying that you that you don't have to give it back? Lo trika de amrle lo nasati lach demei shakil tot revizil. So Rabbah says, no, the brisa is talking about a situation where I say you sold it to me, but I never paid you for it. So here, take the animal back because I never paid you for it. And so that's the situation. So similarly, well, one second, what about the case of you gave it to me as a gift and your father gave it to me as a gift? Fine. You want to tell me you never paid me and now you got to give me? So fine. But my moda beikar, what kind of admission is there in that situation? So the Amrle, because it was given on a condition that I do something for your father, whatever. I needed to do something to satisfy the condition. Below Abdillah, and I didn't do it. So you know what? I didn't steal it, but it's yours, and here you go. Shekol Torach v'zil. Go take your cow and take your ox and go home. So Toa b'derach mitzasiv. Well, one second. What about the found it on the road? Lema ibaylach lahadurili. The plaintiff should say that you should have returned it to me. So Amar Avua de Shmuel. So Avua de Shmuel, the father said, "But Omer Shvua Aveda Matzasi." It's talking about where he said, "I found a lost article below Hayiti Yodea Shehi Shalcha Sha'acha Zarina La." I didn't know it was yours. So as a result, now I know it's yours. Here, take it. So again, in all of these situations, because the thief is saying, "Here, take it," as a result, there is no liability for having sworn falsely, because there's no risk associated with something happening in the meantime, such that there would be a reduction in the liability as a result of the false oath. So in that situation, there's no asham that's required.
Yeah, but we saw above that the owner of the object says to the quote thief, "Wait a second, here's my ox right in front of you." It's only then does the thief admit to it. So it's not as if he retracted and said, "Oh, well, I meant, It's right. I mean, there's a difference here. The thief said, "Oh, I found it. No, I'm returning it to you," as opposed to the owner saying, "There's my ox. What are you doing talking about?"
So in all the cases, both in Rabba's situation and in the situation of this brisa, we are definitely talking about where the victim says, "Hey, there's my ox." The question and the difference is the there literally in front of us and the person is giving back the ox at that moment, or is the, hey, there's my ox over in that field over on yonder, and so as a result you're not giving it back to me immediately, you're just, and again, what is the person first trying to do? The person's first trying to say and come up with an excuse. He's trying
Right.
to justify it being there, and then after justifying it and swearing falsely to it, he says, "You know what? You're right. It's yours. I stole it." And so, in that situation, the question is: was there a time that there was risk that was reduced as a result of the oath? So, if the animal is literally right here and is being handed back, as is the case in the brisa, so there's no risk at all that has been reduced as a result of any of these excuses. But in the case of the that Rabbah said, Rabbah was talking about where the animal was out in the field, and so even if now it's being given back, there was some period of time where there was a risk that the robber was trying to eliminate by making an excuse. And so therefore, because he eliminated that risk, that's why Rabbah says you're going to be liable, because Rabbah says, even though it's not worth anything at the moment, that is worth something theoretically. And so as a result, Rabbah would say similarly with chametz, you'd have to pay, you'd have to bring an asham if you swore falsely about the chametz. Okay, so Tanya, now we have a one more brisa, and with that we'll finish for today. So now the Gemara is going to discuss is swearing falsely that one lacks information relevant to a litigant, because this is going to shed light on the question of whether something that has no value on its own could be considered like money, which is relevant to Rava's question. Again, Rava's asking, if you swear on chametz that passed over Pesach, do you have liability? So Tanya, Amar Bana Azai Shalosh Shavuos saying there are three kinds of oaths that one can make there are three situations where you can make an oath, where these are the facts, and you made an oath, and you're going to be liable for having sworn false. Hikir Bava lo mimotza. If you swear you had no information, but yet you recognized the lost article, but you didn't know who the finder was, bimotza below, but or you recognize the item, the finder, but you didn't know that it was this particular item, or lo bava lo bimotza, or you didn't recognize either the finder or the item. Now the Gemara is going to ask, 1 second, that doesn't make sense. Lo bava lo b'matzah kushta ishtaba. If the person swore that he had no information, and in fact he neither recognized the item nor the finder, well then he's swearing truthfully. So no, ema ba umimitza. It should have said that last case should have said that he recognized both the item and the finder. That's what it meant to say. So Lamai help us out. What is this talking about that says that all of these cases have the same that are grouped together? So Rav Ami Amar Rabbi Chanina. So Rav Ami says in the name of Rabbi Chanina, lift Tor. It's to say that all of these cases are actually not considered a real a false oath, because the oath is not necessarily about money. Shmuel Amar L'chiyu. And Shmuel says that all of these cases you are liable. Now, again, remember that this is all dealing with a single witness. I'm sorry. And no, never mind. My apologies. Don't necessarily say that. So, and this disagreement between Rabbi Chanina and Shmuel is similar to the following disagreement of Baraisa. Titania Hamashpia Eid Echad. If you cause one witness to and to ask one witness to swear for you, and he falsely denies having knowledge of the testimony, Patur. The Tanna Kamma says that single witness is not liable for having sworn falsely because he's one witness, and one witness doesn't cause anybody to pay anything. For Rabbi Lazar, but Rabbi Shimon mechayev. And Rabbi Lazar, the son of Rabbi Shimon, says, yes, you are obligated. So, b'mai kamifliki, what are they arguing? Mar savar davar hagorim lamamon kamamon dami. So the second view, Rabbi Lazar ben Rabbi Shimon says, you know why you're chayav? Because something that could cause a monetary benefit. And Rashi explains, because some people won't want to swear, and instead of swearing, they'll just pay you. So as a result, even though it's one witness who doesn't necessarily make a person have to pay, it could make the person pay. And so as a result, that's considered like real money. And as a result, that false oath triggers an asham. Umar Savar Lav Kamamon Dami, and the Tanakama says, no, it's not like money. And so as a result, you're not going to be subject. So that's going to end our statement. And so we see that the question on some level that Rava asks is tied to this machlokas, and on some level had debate that he effectively has with Rava is tied to this machlokas of Tanaim. So next, the Gemara is going to present a statement of Rav Sheshes regarding how we treat a watcher who denies that he is watching an item. But to find out what that statement is, and for the Gemara's discussion, please stay tuned to tomorrow's daf. Look forward to continuing our learning together. Have a wonderful day, and thank you for sticking with us on this longer daf. Have a great day. Bye-bye.